Salutations to all our future judges. In this video, we are going to see Indian Evidence Act 1872. But before going into the video, I'd like to make few requests to our viewers as well as the subscribers. Kindly do not skip the video. Watch the video from the beginning till the end. If you skip in between, you may be missing very crucial information or very crucial aspects which have been explained. Hence, watch from the beginning till the end. And next request is, please do have a notebook and a pen with you, because various questions which have been asked in Evidence Act in various exams would be mentioned or would be stated. And in addition to this, idea would be given as to how questions could be framed in a particular section. It is very important for you. So you all need to make a note of all these aspects. And in addition to this, some additional illustrations would also be given while teaching the act. Hence, you please make a note of all those additional illustrations as well. They would be of absolute help to you in understanding the particular section. And in addition to this, various ways or techniques would be taught which would help you to remember those sections, or to say some memory techniques would be given. This would be really helpful to you in remembering the sections when you go to the exam. I hope this video would be of absolute and great utility to you. Now, let us try to understand section 10. Section 10 states that things said or done by conspirator in reference to a common design is considered to be relevant. Now let us try to understand this in a very simple manner. Just try to visualize what is being said now. Imagine a bike is being made. To make a bike, there are so many spare parts which are required. A tire is required, a petrol tank is required, a handbar is required, chain is required, light is required, electrical circuits are required, and there are so many spare parts which are required. And all these spare parts are done by different companies and they are supplied to the company which assembles this. Let us take, for example, there is a Bajaj two-wheeler. So this Bajaj two-wheeler acquires various spare parts from various sub-dealers or sub-producing companies. So all these spare parts are purchased and they are assembled and they are given the name of Bajaj, and some specific name may be given with respect to the particular vehicle. So in that case, it is assumed that the vehicle is done by all of the people together. So each and every one is equally responsible for making this vehicle. So in a similar way, if two or more people are joining hands together to do a thing or to commit an offense or an actionable wrong, then it is deemed that each and every person, what they have done is absolutely relevant. Furthermore, in this section, they have given an example also. But before venturing into the said illustration, let us try to understand this section specifically. What they say is anything which is said, done or written. So there are three aspects which we need to know: what a person has said, what a person has done, what a person has written with respect to their common intention. And that should happen after the first time it was entertained by any one of them. Is a relevant fact as against each of the other persons. Imagine in the example what we just quoted, if a person says that he wants to design the wheel of the vehicle. So he has said something. Next thing is, imagine that person has designed the wheel itself. That is, he has completely designed and he has created the wheel itself. So it means he has done that wheel. Or if he is going to write something saying like, this is how the circuit should be, this is how the vehicle should be assembled. If there is something in a written form, then that is also connected to it and it is applicable to each and every person who is doing this. That is what they are trying to say. Now let us move on to the illustration what has been provided. Illustration says, reasonable ground exists for believing that A has joined in a conspiracy to wage a war against the government. So they accuse a person A saying that he has joined a conspiracy to wage war against the government of India. So in that case, imagine a person is conspiring against or waging a war against the government of India. So what this person is doing is contributing to the idea of waging a war against the government. So what will happen is, to do this, there may be many people who are working together to wage a war against the government. One person may procure arms from Europe. The other person may collect money from Calcutta. And there may be one person who may be persuading the other people to join the group or to wage war against the government. And the other person may be advocating all these aspects. He may be, say, giving some YouTube lectures or say some sermons or any other aspect of spreading this idea between the people. And in some cases, there may be people who are supporting to transmit the money from one place to another. And another aspect is also there, where the people combine all these people together. So there may be so many people working on this. However, if this A takes part in this in some form, it is considered that he is waging a war against the government. He may not know how the money is generated. He may not know who are all the people who are spreading this aspect, but still he is bound, and whatever has been done is relevant. And all these aspects might have taken without the knowledge of A or with the knowledge of A, or before A ventures into it or after A ventures into this aspect. But still everything is considered to be quite relevant to prove the existence of the conspiracy. Now let us move to section 11. When facts not otherwise relevant become relevant. You can imagine a situation, sometimes there may be some facts which are not at all connected or which are in no way relevant to the case in hand, but sometimes they become relevant also. When there are two conditions, there are two instances we can say where it becomes relevant: if they are inconsistent with any fact in issue or relevant fact. And the next is if by themselves or in connection with other facts they make the existence or non-existence of a fact in issue or relevant fact highly probable or improbable. There are saying two scenarios. Now let us see the illustrations. The first illustration is, the question is raised whether A has committed a crime at Calcutta on a certain day. The fact that on that day A was at Lahore is relevant. The fact that near the time when the crime was committed, A was at a distance from the place where it was committed, which would render it highly improbable, though not impossible, that he committed it, is irrelevant. There are two aspects which are discussed in this particular example. They are saying this A has committed a crime in Calcutta, but on that day A was at Lahore. That is a quite relevant issue. However, I would like to add one more information. This is called as plea of alibi. What they do is, imagine a person is being accused saying that he has killed a person, say in Calcutta or in Mumbai. Let us, for the sake of example, let us assume it is in Mumbai. He has killed a person in Mumbai. But actually on that particular day, at that particular time, he was traveling abroad. Then the person who claims this, that is the accused, who said that he killed the person in Mumbai, he says that no, I didn't kill him. I was traveling, I was going abroad on a flight. Then this accused has to prove that he was not there, he was not present there. To put it simply, if someone is saying that I was not present there at that time, it is the duty of the person who is claiming it to prove it. Generally, the criminal procedure is that the person, the prosecution or the government side has to prove that the accused has committed the crime. But in case of plea of alibi, the accused has to prove that he is innocent or he was not present there at the time when the offence took place. This is an additional information I am providing. This could also be asked in the judicial exams. Now let us come to the next aspect in the same example. It says, when the crime was committed, A was at a distance from the place where it was committed, which would render it highly improbable. Let me try to explain this in a much more simple way. Imagine there is a person or a murder was committed with a knife, with a small knife, a murder was committed. And the person who is accused was at a distance of say around 40 feet from the place where the murder took place at the time when the murder took place. In that case, it is obvious that this person could not have killed that person. The probability is quite less. It is not proven that it is impossible, but the probability is very less. The only option is that he could have thrown the knife with full force, say from 40 feet. But the chances of that knife killing him is very less, or to say it is improbable. So in that case, this becomes quite relevant to the case in hand. Now, let us move to the next example. The question is whether A committed a crime. That is a question which is raised. So, in that case, they are saying the crime could have been committed by either A, B, C or D. Now, only A is being accused, whereas B, C or D is not accused. So, the fact that except A, no one else could have committed the crime, if there is any fact showing this particular aspect, is relevant. And if there is any other aspect which says that or which proves that B, C or D did not commit the crime, is also quite relevant. One is, other than this person, that is A, no one else could have done it. That is one. Second thing is, B, C or D could not have done it. There is a fact which shows this. Then that is also quite relevant. Now, let us move to section 12. It says, in suit for damages, facts tending to enable court to determine amount are relevant. In suits in which damages are claimed, any fact which will enable the court to determine the amount of damages which ought to be awarded is relevant. They say so. As you all know, in some cases compensation is being or damages is being given. Imagine there is an acid attack victim. A lady has been attacked with acid. She suffered severe injuries, burn injuries. So in that case, the court will determine how much the lady or the woman has suffered. So to that extent, damage will be determined. So that is what they are trying to say in this section. So what are all the facts which help the court to determine the damage which is caused, based on which the amount would be determined. Imagine a person has slapped a lady and there is no physical damage to the lady. There is only some mental disturbance or mental agony which has been caused. Now let us go to the next scenario where a man has thrown acid on the face of a woman. So in both these cases, damages are completely different. So based on the damage or the injury caused to the women, the damage would be determined. So facts which help, or in case of suits, now this example was given now on the criminal side. Now if there is a property which has been damaged, in that case the amount of damage or the agony which the person who is the owner of the property will incur or will have would be determined, and based on that the damage would be determined. So this is also quite important. Now let us move to section 13. Facts relevant when right or custom is in question. There are certain facts which become relevant when a right or custom is being questioned. They are given two scenarios in this regard. First one, so if there is a transaction which creates or claims or modifies or recognizes or asserts or denies a particular right or custom, or which was inconsistent with its existence, with the existence of that right or custom, then in that case that transaction is considered to be a relevant fact. Now let us come to the second scenario. Particular instances in which the right or custom was claimed, recognized or exercised, or in which its exercise was disputed, asserted or departed from. So there is a right which is being questioned or a custom which is being questioned. If somebody is disputing that right, so that particular instance, imagine he is saying that a person does not have a right, he is disputing that right. So that instance is relevant. The other scenario, somebody is saying, somebody is asserting, yes, this person has got a right, or he is departing from it. He is saying, no, no, he had the right prior to it, but now he doesn't have the right. So he is departing from it. So in all these instances, it is considered to be quite relevant. Now, let us move to the illustration which is given. The question is whether A has a right to a fishery. Now imagine the A is saying, no, no, I have got the right to fish in this place. Imagine there is a big lake in which A has a right to fish. And now somebody is questioning that right. So in that case, if there is a deed which confers the right on A, saying that A has got a right to fish in that particular lake. In that case, the deed is quite relevant. Now, there is a mortgage of the fishery by A's father. Imagine that right which he has. This A's father has pledged it to somebody else or mortgaged it to somebody else. Then that is also quite relevant. Then this A's father is saying, my son has got a right to fish here. He is granting his rights to his son. Now, there is a particular instance in which A's father exercised the right. In a particular instance, his father has given the right to his son A. Or that right, imagine this A has been fishing there for a while. This neighbors, they come and say, no, 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 you're not supposed to fish here. They are preventing or stopping him from fishing in that particular area. Then all these aspects are considered to be relevant facts. If you like the video, do press the red color subscribe button as well as the all button so that you receive the notifications whenever a video is posted in this channel. If you like the video, do press the thumbs up button and share the channel with your friends. You can motivate your friends by sharing the channel. Let us join hands together and contribute for a learned society. Thank you.